Yes, I think. Yes. Because they have crossed the age bar. These petitions, there are 4 petitioners. But there are totally 10 people like that. Aspect we leave to the High Court. All 11 have crossed the age bar. What about seniority? You're saying you'll forgo everything. Fresh appointments.
Ms. Haripriya, there are also elements. It's not just you get into the job. You have to undergo that 1 year training. You lose your seniority. That's one of the things. All across the board in the entire judicial system of Kerala, the prejudice that you are talking about, they will continue to suffer this prejudice of being junior to their batchmates all through their service career. That's also something, although they might be desperate enough to say that please give us even now. And you see, as you lose opportunity by growing older, you gain also opportunities by growing older. I'm just stopping there. And that's Article 1416, right? How do you also deprive the people who have qualified in the last 6 years of the vacancies which actually they should be competing for? You are usurping their, see again, it's a cascading thing. It's not just one thing, you see.
The rules today, what do they provide? That
35%.
35% has been provided. When did that amendment come up?
2017.
17, that amendment came.
It's part of the comment. There's one more.
Was released. Is that, by the way, is that that amendment of 2017 somewhere in the compilation, just for the sake of?
Yes, it is there. It is there. Yeah.
That is document, in case you have it. I mean, it's nothing turns on it.
Your Lordship, you all submitted detailed submission on the main issue before the Constitution bench as well. Your Lordship will just consider it while passing the final judgment. We'll be grateful. Our submissions are on record.
But we don't need to go into the broader issue of, change in the rules of game here at all.
Not in Kerala case, but it would apply to Tej Prakash as
Other
well.
cases, of course, in fact, in the other cases, if few people are here, you'd like to assist us, you're most welcome to.
Yes, Your Lordship. So it is there in our submission. So as and when the necessity arises.
Kerala case, it doesn't arise strictly speaking.
Yes, Your Lordship.
Were given to these in that batch in the 2017. Was it made subject to the outcome of this petition?
Even today, even this appointment letters are all said subject to result of this writ petition. Every single appointment made, even after that, because some of those vacancies carried forward. So every single appointment made, the appointment letter clearly states subject to result of this writ petition, quoting the numbers.
Are all of them parties here?
Not three of them, because others won't be affected.
Are
So
parties.
we said only 3 will be affected, so only 3 are here.
There's new release documents. New
Who
release
is appearing
document
for
number-
those three candidates? The three candidates respond numbers 9, 11 and 12.
One, Mr. Kailash.
You are appearing? What do you have to say? Your appointments were made subject to the result of this writ petition, right? That's what we say, yes. Responsive.
Select list. Sorry, Lord. There was no stay of operation of the select list. Lord, equity, fairness and Lord, justice demands that Lord, they should be allowed to continue. I am not holding that the petitioner should not be given raise. And
Mr. Naidu,
it is not our, sorry.
Please unmute.
Ms. Naidu, please unmute yourself.
No, they have.
Yes.
Yes, Mills. Now I have been unmuted. Those who have already been in minutes, the candidates that have been selected having discharged judicial functions blemishlessly all these years, they may not be upset.
Now, what about these candidates, who are before us? The left out candidates, 11 of them, right?
Yes, I may be pardoned for repeating that we have taken consciously and the full court has unanimously accepted that one. And then this decision in the interest of the efficacy of the administration, judicial administration. And we have not played favorites and no mala fides. So such a decision, could it be upset down the line, all these years later?
Can I take 1 minute before I dictate? Just 1 minute. Lord, 3 things, my Lord. One, like a lordship rightly seen, the rule, the scheme, the notification. Nowhere prescribes minimum marks for bias. Now, why I'm saying after the selection 6th March, 5th April, we filed the writ. I'm just saying we have been a vigilant litigant. We filed the writ. The reference order was passed in November 17.
5th of April is the writ petition.
6th March is the selection list, 5th April, with exactly 1 month after.
Give us the date of the new notification.
Yes, my lord.
Amended notification.
Notification date.
My lords,
What is the date of the
That's
notification?
document number 17
Petition.
in my
It is a writ petition.
That's document number 17, 20th September 2017.
20th September 17 is the amended.
Yes, amended. Document number 17, black letters numbers 104, my lords.
So 5th April, writ petition is filed. 14 November is a reference order. Now thereafter, we tried mentioning a lot because of the heavy backlog, etc. Matter couldn't get listed. Now if today your lordship finds that the minimum prescribing cutoff marks is not permissible, some relief may be granted to them. I'm not saying I don't want them to go out. Ideally, this ideal situation for us is we are there, they are there. But then I'm saying molding the relief, some relief for us. Otherwise, if your lordships today finds that the minimum fixation of minimum cutoff marks is wrong and no relief is granted to us, my lord. Frankly speaking, my lord, none of us, maybe benefit from that. So I don't know what can lordship may kindly, with your last experience, do something by which we are also protected. I understand, but
The reality is that actually 6 years our
the full court prescribes saying no cutoff. Administrative committee says, oh, that they would not have meant it. Yes, my lord.
You don't need to
So only
on that.
requesting is now that at least the relief, something may be done for us. That's all. I can't say anything.
My lords, on the relief part, one respectful submission, my lords. Apart from this judicial post, my lords, there are a lot of administrative posts as well as tribunals also. Now, motor accident claims tribunal, ILA. So they can be accommodated so many places, my lords.
Expending.
My lords, and
All
my lords,
right, I'll
interestingly,
tell
my
you.
lords,
I may submit minutes. I may submit, it may be ironical. Well, they say that relief has to be granted. Well, in fact, principle could be laid down. History bears out minutes in every line of judgment, beginning from Keshwananda Bharati, Maneka Gandhi. Principles have been laid down, but not the relief granted. Because by then, it was not possible.
Saying, Mr. Naidu.
As I look at that, bench on 14 November 2017, a bench of 2 judges of this court referred a batch of 4 petitions, which invoked the jurisdiction of this court under Article 32 of the Constitution. The Constitution bench in Sivanandan CT versus High Court of Kerala, 2018, 1 SCC 239. Full stop. 11 petitioners are before this court, all of whom are candidates aspiring to be selected as district judges in the higher judicial service of the state of Kerala in pursuance of a selection of 2015. Good stop. The In the state of Kerala, the Kerala State Higher Judicial Service Special Rules 1961 came into force on 11 July 1961. These rules have been framed under Articles 233 and 309 of the Constitution. Full stop. The rules provide for three categories. The rules provide for the constitution of the service into three categories. Colon, bracket 1, super time scale district and sessions judges, semicolon, bracket 2, selection grade district and sessions judges, and bracket 3, district and sessions judges, including additional district judges. Full stop. The dispute in the present case, the dispute in the present batch of cases pertains to the third category noted above. Full stop. Rule 2, bracket C, provides for appointment to the third category. Full stop. Rule 2C3 stipulates that 25% of the posts in the category shall be filled by direct recruitment from the bar, into inverted commas, on the basis of aggregate marks stroke grade obtained in a competitive examination and viva voce conducted by the High Court. Inverted commas complete. On 30 September 2015, a notification was issued by the High Court of Kerala, by which applications were invited from qualified candidates for appointment as district and sessions judges in the Kerala State Higher Judicial Service by direct recruitment from the bar. Full stop. Paragraph 5 of the notification provides for the mode of selection. Full stop. Paragraph 5 stipulates that the selection would be on the basis of a competitive examination consisting of a written examination and a viva voce. Full stop. The total marks assigned for the written examination were 300, comprising of 2 papers, each carrying a maximum of 150 marks. Full stop. General candidates and candidates belonging to the OBC category who secured 50%, and SC/ST candidates who secured 40% aggregate minimum marks for both the papers together were to be declared as qualified for the viva voce. Full stop. The maximum marks prescribed for the viva voce were 50. Full stop. Para 5 stipulates that, into inverted commas, the merit list of successful candidates will be prepared on the basis of the total marks obtained in the written examination and viva voce, into invert commas complete. ये आपको मिल जाएगा page 873 in 501.5. The notification किया ना बताया ना उसके पहले ये लिख लो after the rules of 1961 were notified, the High Court of Kerala had by notification dated 13 December 2012 prescribed the scheme for the examination. Page 26. Yeah. The scheme as notified by the High Court contain the following stipulations. Colon, bracket 1. The Kerala Higher Judicial Service Examination will have a written examination for 2 papers carrying 150 marks each and a viva voce carrying 50 marks with a total of 350 marks so assigned, semicolon, bracket 2. While separate minimum marks were not prescribed for each paper, general category candidates who secured at least 50% in the aggregate and SC/ST candidates who secured at least 40% in the aggregate for both the papers together would be qualified for the viva voce examination. Semicolon, bracket 3. The viva voce test would be conducted into invert commas in a thorough and scientific manner to invert commas complete for a period ranging between 25 to 30 minutes for each candidate. Semicolon, bracket 4, into invert commas, there shall be no cutoff marks for the viva voce. Semicolon, bracket 5. The merit list would be prepared on the basis of marks obtained both in the written examination and the viva voce. Full stop. Following the notification which was issued by the High Court on 30 September 2015, the written test was conducted on 12 and 13 March 2016. Full stop. On 17 December 2016, the notification regarding candidates who had qualified in the written test came to be published. Full stop. Following this, between 16 January 2017 and 24 January 2017, the viva voce for all the qualified candidates was conducted. Full stop. Next. On 27 February 2017, after the oral interviews, after the viva voce was conducted, the Administrative Committee of the High Court passed a resolution by which it decided to apply the same minimum cutoff of marks which was prescribed for the written examination as an eligibility as a qualifying criteria in the viva voce. Let's stop. In coming to this conclusion, the administrative committee was of the view that since appointments were being made to the higher judicial service, it was necessary to select candidates with the requisite personality and knowledge, which could be ensured by prescribing a cutoff for the viva voce in terms similar to the cutoff which was prescribed for the written examination. Full stop. The resolution of the administrative committee was approved by the full court of the High Court of Kerala on 6 March 2017. Full stop. While approving the decision of the administrative committee, the full court was of the view don't say that. Just leave it at 6 March 2017. Let's stop. The decision of the full court and the resultant promulgation of the list of successful candidates led to the institution of writ petitions before the High Court of Kerala. Before this court under Article 32 of the Constitution on 5 April 2017. Let's stop. The candidates who are before this court are aggrieved by the fact that as a result of the application of the cutoff in the viva voce, they have been ousted from selection, though in the aggregate of marks in the written examination and the viva voce, they would rank higher than many of the candidates who have been selected. Full stop. This specific grievance was urged before this court when notice was issued, particularly in relation to three respondents, respondents 9, 11, and 12. Full stop. When the petition was taken up by a two-judge bench of this court on 14 November 2017, a reference was made to the Constitution bench following an earlier reference made to the larger bench in Tej Prakash Pathak. You have the citation of that? 2013 4 SEC 540. Full stop. By making a reference to the Constitution bench in the earlier decision, the principal issue which has been addressed is whether it is open in law when a selection process is instituted to change the rules of the game midstream. Full stop. Uh, In that context, reliance was placed on an earlier decision in K. Manjushri versus State of Andhra Pradesh and another, 2008, SCC 512. Full stop. The view which has been prima facie expressed, don't say that, the view in Manjushri has been doubted on the ground that the principle which has been laid down in that case would appear to run contrary to an earlier decision in that 1974. Do you have that? 1974 to 20. Stop. Next. During the course of the hearing, we have heard arguments on behalf of the petitioners by Mr. P.V. Dinesh, Learned Counsel, Mr. V. Chidambaresh, Learned Senior Counsel, Ms. Haripriya Padmanabhan, and Mr. Ragan Basant. That's the four of you, right? Nobody else? Next. In the view which we are inclined to take in the present case, it does not become necessary to rule on the broader constitutional issue on which a reference has been made in Tej Prasad Pathak. Full stop. The reason why we have come to this conclusion would be elaborated shortly hereafter. Full stop. Principally, the modalities which have been followed by the High Court of Kerala for selection, the course of the process, have been assailed on 4 grounds. Bracket 1, in specifying a cutoff for the viva voce, the High Court has acted in a manner contrary to Rule 2, bracket C, bracket 3 of the Kerala of the Kerala State Higher Judicial Service Special Rules 1961, to brackets you say 1961 rules. 2, the scheme which was notified by the High Court on 13 December 2012 had expressly provided that there shall be no cutoff for the purposes of the viva voce. 3, according to the scheme which was notified in 2012, the only criteria for shortlisting of candidates, that is the notification, right? This is scheme. Yes. According to the notification, the only criteria for the purpose of shortlisting candidates would be the length of service rendered by candidates at the bar, which was to operate in a situation where the number of candidates was found to be unusually large. Semicolon, and bracket 4, the decision of the decision of the full court of the High Court, or the decision of the full court to prescribe a cutoff for the viva voce was notified much after the viva voce was held, as a consequence of which candidates had no notice that such a requirement would be introduced at the inception of the process. Full stop. Mr. Damasheshasdi Naidu, Learned Senior Counsel, has appeared on behalf of the state of Kerala, for the High Court of Kerala, while Mr. Swainso appears for respondent number 9, right? Or 11? 11. Mr. Kailash Nath Pillai appears for respondent number 11. Next. The 1961 rules clearly specify that "25% of the aggregate posts which are to be filled in by direct recruitment from the bar would comprise of the marks obtained, would comprise of the list of candidates selected on the basis of the marks obtained in the aggregate in the written examination and the viva voce." Full stop. These rules, as already noted earlier, have been framed in exercise of the power conferred by Articles 233 and 309 of the Constitution. Full stop. After the statutory rules were notified on 11 July 1961, the High Court of Kerala published the scheme of the examination for recruitment of members of the bar to the Kerala Higher Judicial Service on 13 December 2012. Full stop. The scheme so notified specifically provides that there shall be no cutoff marks for the viva voce. Full stop. The notification, which was issued by the High Court on 30 September 2015, for the conduct of the ensuing examination, provided that the mode of selection would consist of 2 written papers, each carrying 150 marks, and that candidates from the general and OBC category who secured a minimum of 50% marks, into brackets, relaxed to 40% for SC/ST candidates, bracket, would qualify for the viva voce. Full stop. The notification spells out that the aggregate of marks in the written examination and the viva voce would form the basis of drawing up the merit list. Full stop. In the above backdrop, it is evident that when the process began, the process of selection commenced, all candidates were clearly put on notice of the fact that the merit list would be drawn up on the basis of the aggregate marks obtained in the written examination and viva voce, semicolon, that candidates with the prescribed minimum, candidates whose marks were at least at the prescribed minimum in the written examination would qualify for the viva voce. And bracket 3, there was no cutoff applicable in respect to the marks to be obtained in the viva voce while drawing up the merit list in the aggregate. Full stop. The decision of the High Court to prescribe a cutoff in the viva voce was taken by the Administrative Committee on 27 February 2017, after the viva voce was conducted between 16 and 24 January 2017. Let's stop. The process which has been adopted by the High Court suffers from an element of being, suffers from several infirmities. Let's stop. Firstly, the decision of the High Court was contrary to the provisions of Rule 2C(3), which stipulates that the merit list would be drawn up on the basis of the marks obtained in the aggregate in the written examination and the viva voce. Semicolon. Secondly, the scheme which was notified by the High Court on 13 December 2012 clearly specified that there would be no marks, that there would be no cutoff marks in respect of the viva voce. Thirdly, the notification of the High Court dated 30 September 2015 clarified that the process of shortlisting which could be carried out would be only on the basis of the length of service of the members of the bar, should the number of candidates be unduly large. And fourthly, the decision to prescribe a cutoff for the viva voce, the decision to prescribe cutoff marks for the viva voce was taken much after the viva voce tests were conducted in the month of January 2017. Let's stop. For the above reasons, we have come to the conclusion the broader constitutional issue which has been referred in Tej Prakash Pathak would not merit decision in the facts of the present case. Let's stop. Clearly, the view which was taken by the High Court, the decision which was taken by the High Court was ultra vires rules 2(c)(3) as it stands. Let's stop. As a matter of fact, during the course of the hearing, we have been apprised of the fact that the rules have been subsequently amended in 2017 so as to prescribe a cutoff of 35% marks in the viva voce, which, however, was not the prevalent legal position when the present process of selection was initiated on 30 September 2015. Let's stop. Undoubtedly, the High Court may have been, the High Court was, the Administrative Committee of the High Court decided to impose a cutoff for the viva voce examination actuated by bona fide reason of ensuring that candidates with the requisite personality assume judicial office. Let's stop. However laudable that approach of the Administrative Committee may have been, such a change was required to be brought in by a substantive amendment to the rules, which came in much later, as noticed above. Let's stop. The High Court was, this is not a case where the rules or the scheme of the High Court was silent. Full stop. It is a well-settled
Ratified by the full.
It is a well-settled principle of law that where the statutory rules are silent, they can be supplemented in a manner consistent with the object and spirit of the rules by an administrative order. Full stop. In the present case, the statutory rules expressly provided that the select list would be drawn up on the basis of the aggregate of marks obtained in the written examination and the viva voce. Full stop. This was further elaborated in the scheme of 2012, which prescribed that there would be no cutoff marks for the viva voce. It's also reflected in the note. Full stop. This position is also reflected in the notification of the High Court dated 30 September 2015. In this backdrop, we have come to the conclusion that the decision of the High Court suffered from its being ultra vires, the rules which were framed under Article 233 and 309, besides being manifestly arbitrary. Full stop. Having said this, the question which now arises before the court is regard to the relief which can be granted to the petitioners. Full stop. The final list of successful candidates was issued on 6 March 2017. Full stop. The candidates who have been selected would have now been working as district judges for a little over, for about 6 years. Full stop. In the meantime, all the petitioners who are before the court have not functioned in judicial office. Full stop. At this lapse of time, it may be difficult to direct either the unseating of the candidates who have performed their duties. Full stop. Unseating them at this stage would be contrary to public interest, since they had gained experience as judicial officers in the meantime. Full stop. While the grievance of the petitioners is that if the aggregate of marks in the written examination and viva voce were taken into account, they would rank higher than 3 candidates who are respondents to these proceedings. Equally, it cannot be lost sight. We cannot lose sight of the fact that all the selected candidates are otherwise qualified for judicial office and have been working over a length of time. Full stop. Unseating them would, besides being harsh, result in a situation where the higher judiciary will lose the services of duly qualified candidates who have gained experience over the last 6 years. For these reasons, we have come to the conclusion that it would not be possible to direct the induction of the petitioners into the higher judicial service at the present stage. Full stop. Many of the petitioners would have since joined the bar and would be in active practice. Full stop. It needs to be clarified that their having failed to gain selection to the higher judicial service in the process which was initiated on 30 September 2015 is not a reflection either on their merits or ability, and shall not come in the way of their being considered for any other office, judicial or otherwise, in the future. Full stop. Subject to the full stop. In the view which we have taken in the above terms, we have not considered it necessary to answer the broader question of constitutional, the broader question which has been referred to the Constitution bench. Full stop. The question is kept open to the Constitution bench. Full stop. The petitions. Besides, the question has been squarely raised in certain other cases which form a part of the present batch of cases in which arguments are being heard by the Constitution bench. Full stop. The petitions are accordingly disposed of in the above terms.
Thank you. Let's say one small correction, my lords.
Yes.
Decision of the High Court on the administrative side, my lords. Lordship has said that decision of the High Court.
On the administrative side. I'll correct you. So these 5 matters are over right now. 4 matters: 1.5, 0.6, 0.7, and 0.30. 4 matters. Now we take up Rajasthan, right?
Deeply.
Lordship,
ये वो रेफरेंस भी हो गया.
Lordship, may I Lordship, may I request, Lordship, that I may be taken in the last, as I had requested that these are the clerical staff, which is different from others, Lordship.
Now this is Tej Prakash Pathak, no? That's the lead matter.
That's the lead matter, right?
Lordship.
So
This
what
is
we could do now is, we will take up, we had said that we will take up the Rajasthan. You don't want to take up, we'll start with Rajasthan. This is a lead matter.
Lordship, I can start, but Lordship, what is it that it is different? It is different from others. So I may be in the last and then I can point out few things which are different
Does
from
the-
them. And it
Mr.
would be
Agarwal, does the
easier.
question arise here? Straight away.
It's straight away, right?
So that's the reference order.
Yes, it's a main reference order.
Main reference order, so Lordship, what I am saying that. Lordship, in the last Lordship.
Which one should we take up? Who's now ready to the hill? Tell us. Mr. Mukherjee, where are you? You are for the petitioners in Manipur.
I'm there, Manipur.
And you are in Manipur.
It arises in your case also, or are you saying that it won't arise?
No, it's completely
Then
different.
you are contesting that.
It's completely different.
That is Salam Samarjit Singh versus High Court of Manipur,
Only one more thing.
501.4.
Refer to the PDF file, Manas, which will make it.
Yes, that will be much better.
I've learned it the hard way, Manas, but I'm learning.
It's so nice. See, it's so good that everybody is also on the same. And happy the registry is now circulating these files to all the lawyers. And that's very important.
You want us to take the paper book?
The PDF paper book, Manas,
Paper book.
may I,
501.
straight take your lordships to the written submissions which we have filed, that your lordship will find at page, PDF page 460. Sorry, 480, I'm so sorry, 480.
460 is nice.
Just 1 second.
480. Like it, I'm still learning.
अच्छा किया मैंने कि हाई कोर्ट को नहीं बताया कि आप जीरो से नहीं है 5 सुप्रीम कोर्ट के मोटे मोटे जज बैठे वहां पर
ये filed by
इसके पास है सिमिलर
Page 480, Manas.
80.
Yes.
List of dates.
List of dates are broadly large hinges on it.
So we'll quickly run through the list of dates.
Yeah.
Good always to.
That'll be easier for us.
That's the table, right? Brief facts and chronology or
That
480?
the list of dates will start, Manas, with the date and pages. That is
480 you said.
480 or 482.
This one.
It starts at 482 PDF.
So 2005 lordships will find are the recruitment rules under 234-309. And this was after the All India judges case, based on the Justice Shetty recommendations. Rule 7 is what is relevant for us, Mala, the relevant provisions.
Two 2005. Now we are concerned with Rule 7.
But no cutoff. Yes, Mala. So if you kindly see the relevant provisions, Rule 7, method of recruitment, qualification, reservation, so and so. Then, Mala, Schedule B to the MGS schools, competitive examination, limited departmental examination, written examination of 3 papers of 100 marks each, interview, viva voce, 50 marks. There's no cutoff.
These chapter of papers now we must have. Proposing that, now whoever has papers should be directed to make a contribution to the Supreme Court Bar Association Welfare Fund.
We're seeing papers on the tables.
I was just pleading with the Chief Justice for an exemption for the judges,
It was rejected.
Rejected.
It was rejected.
In fact, I make it a point not to take any paperbacks from stores, man. I tell them the next generation will not get paper. The young kids who man the stores, I make it a point not to take any paperbacks or even receipts. I said, please put it on WhatsApp and send the bill to me. If necessary, I'll download it.
All of you have all these papers. What are you doing with papers?
No, this is because we got the PDF only yesterday, my lords. I got the PDF only yesterday, so I converted it fast.
Yes. We've seen you.
Largely,
I've been on iPad, I've seen
we
you.
have decided code 1 to 5 will have the iPad. With the,
No, but seriously, because we must now move to this.
Once you completely shift, you'll know
Yes, sir.
how easy and
How
how
easy it is.
advantageous it is.
they are very adept at it. They do it very fast. We are still learning. Everybody keeps on telling. When I see her, I hide my papers. She says, "Where is the iPad?" She scolds me. So I told her I'm still learning.
It's always a process.
Yes.
All right, Rule 7.
Yes, Rule 7. Now, also, you kindly see Clause 1 a bit
But
below
hats
that.
off to my brothers. Huh? I mean, everybody has really been so cooperative. Everybody is sort of very eagerly doing it. And for us, it's a new normal, actually.
It's a matter of getting used to it. Delhi High Court, I think almost all judges are trained.
Yes.
Yes, Manoj. So Schedule B says, Manoj, Lordship will kindly have Clause 1. Competitive examination, limited departmental examination, written examination, 3 papers, 100 marks each. Interview of viva, 50 marks, no cutoff. The cutoff comes in the general instructions. All candidates who obtain 60% or more marks or corresponding grade in the written examination shall be eligible for viva voce examination, provided that the SC/ST candidate, I am one of those, who obtain 50% or more marks or corresponding grade in the written examination shall be eligible for viva voce examination. So, records will show I got 50% plus. I was the only candidate who was eligible in the examination. 17 candidates took part in this examination held in 2013. The advertisement, Lordship will find, there are different grades. We are not concerned with the grades here.
All right.
Lordship will kindly come to page, running PDF page 483. I need to show one clause in the first block.
That clause 2 is important. Selection of candidates shall be made on the basis of the cumulative grade value
That's it.
obtained in the written and viva.
Absolutely. And then, my lords, will kindly see the last clause 3.
I'm sorry, I didn't want to interrupt. Only one thing, my lord, here are the rules. My lords have read mode of evaluation of performance and grading written and viva shall be as follow.
70 so and so, below 40% F failed.
Where are you?
No, that's not.
Just a minute, just a minute.
Table.
483. Fail, it's only a grade.
you
No,
just-
please, let me complete. You will have a chance. But this is difficult. Fail, it's a wrong interpretation. This is what High Court should not do this. He's appearing for the High Court.
Well,
There's nothing known as
I'm appearing for the High Court.
Oh, I'm so sorry.
I'm aware that I'm making
Ah,
a
so but
submission.
High
on
Court
behalf
should not
of
do this. There's nothing known as fail. It's only a grading given here. Where does the grading say it is fail? Or should we kindly see the grading? The percentages have not yet come to the grading. I'm still in page 482.
But the grade value is zero basically.
Yes.
For below 40%, you get zero.
Whatever it is. Now, Lakshmi, kindly see the first block relevant provisions, clause 3.
3%.
Clause 3(3).
This is,
So 2 says selection after selection of candidates or based on the cumulative, which your Lordship just read.
Clause 3(3) is all necessary steps.
Yes.
Read
This
it.
is what the High Court is relying on.
Yes.
So all necessary steps not provided for in these rules, Lordship will note the word rules, for recruitment under these rules shall be decided by the recruiting authority. So all necessary steps, those are administrative steps.
Now, these rules which have been framed by the Manipur Judicial Circle, the 2005 rules are under Article 233 or
234, 309.
309.
Then the grading is given at the next block at page 483.
Right.
So 70% grade O, A plus, A, B plus, B, C plus, C, F. So F is where you get below 40% is 0. The grade value is 0. So you don't get a step up because in any case 60 and 50% is a cutoff for the written examination. But you saw that in the beginning. 60 for general candidates, 50 for SC. I'm one SC
But
candidate.
it said written examination and Viva OC exam over here.
Yes. So the cumulative grade.
It's
But for Viva, I showed 50 marks, but no cutoff. That's an accepted position. At that date, there was no cutoff. Then comes the advertisement of 15/5/2013. So there was applicant direct recruitment to one vacant unreserved post of district judge entry level. Then while 17/10/2013, the written examinations were held. 17 appeared at the examination. The list is at page 122 PDF. And there was a notification saying that none had qualified. Lots will note this. 17/10/2013, it said none had qualified. I did a RTI and on 29/1/2014 found that I had 52.8% marks. Therefore, I stood qualified. Then I asked for a review.
When were the results declared?
Yes, Manas, the results are 17/10/2013.
That's the date of the result
Yes,
itself.
that's at page 122.
Okay, I get it.
So 4/2/2014, I asked for a review of this rejection of even my candidature. Then the High Court 7/2/2014 issues a corrigendum saying that I had in fact qualified. That I was the sole successful candidate. Then, my lords, before the Viva could be held, without any intimation to me, a full court resolution was passed on the 12th of January 2015. And this, my lords, makes a little interesting reading. If I may read this document once, my lords. It was specific to me. And that PDF, Lordship will find at page 147. This document is important in the full court resolution at page 147 PDF. There's the minutes of the full court held on 12/1/2015 at page 147 PDF. And this full court resolution is specific by taking my name. It's almost the same as the P. Venugopal dietary aims, whether your lordship struck down that act saying that you cannot have a single specific instance of one person. So that becomes a malice in law. Here, my lords, with respect to the High Court, Kindly see the resolution.
Keep
Considering
saying.
all the relevant provisions of Manipur judicial. Malak, this is, let's have a look at the resolution at page 147.
2015.
Yes. 12/1/2015. Considering all the relevant provisions of Manipur Judicial Service, Shri Samarjit Singh, who secured more than minimum qualifying marks in the written examination, is qualified for interview and he shall be called for facing interview. Now, qualifying marks for interview, Viva Bose, a question as to what percentage would be the minimum qualifying marks of passing interview, Viva Bose is discussed. The following provisions of sub-rule 3 of Schedule B of Manipur Judicial Services rules are taken into consideration, and they rely on that clause 3 which I read, Manas. All necessary steps not provided for in these rules for recruitment under this rule shall be decided by the recruitment authority. The mode of evaluating the performance of grading in the written and Viva Voce shall be as specified below. Evaluating performance in competitive examination of judicial selection, Doctor will skip that. Then, Manas, below the table, the full court, after considering the power conferred on the recruitment authority in the above states, rules and percentage of marks with grade value given above, resolve that no one shall be declared passed and selected for appointment unless he secures minimum 40% from the interview by Babose. So this is almost like an executive instruction. They introduced this by using the so-called enabling power, which in my respectful submission is not a power which really amends the rule, and says that 40% now. So Rajiv has seen that clause 2 said cumulative of Viva. It does not prescribe any cutoff marks. So this happens. Then the Viva happens minus 12/2/2015, 1 year after my selection was held to be valid in the first stage, which is 7/2/2014. I showed the letter. The corrigendum came that I am the sole candidate. They waited for 1 year, held the full court, and designedly said that there will be a cutoff of 40%. And the Viva was held, and I apparently got 18.8% marks out of 50, and therefore that cutoff of 40% was not met by me by 1.2%.
You got how much you said?
18.8 marks, Manas, out of 50. So the cutoff would be 20, because 40% according to the High Court.
Unlike the previous case which we decided, Kerala,
Yes.
the Viva cutoff was decided here before the Viva was actually held.
Yes. But there was a 1 year lag time.
Right.
I was not informed about this. I had no knowledge of this cutoff in any case. Had I knowledge, I do not know what I could have done. But I could have still challenged it at that stage.
It was not as if the Viva was held and thereafter they decided to.
But the selection process was on. So therefore,
that issue of midstream change in rules applies here.
And then this lag time of 1 year also, they kept it pending.
Initially, they said none had qualified.
Yes.
So they gave a corrigendum to that. So this process also, otherwise you are not even in the fray.
Initially.
Now, because of the corrigendum, you come in the
I come in the fray. As a low
They
candidate.
allow you to participate in the
Participate,
Viva,
but
but
with
in
this-
the Viva, you don't meet the benchmark.
According to them, the benchmark. And the rules now stand amended in 2016. They actually formally amend the rules in 2016. Wait, Baba, if you keep on it. 9/3/2016 is a formal amendment to the rule, man. Judgments all. Yes, sir. So Lordship will find that amended rule at page 285 PDF, 9/3/2016. So there's almost
285.
285, 1 year, 1 month after the full court resolution. In between, the viva takes place. I was told of the full court resolution after the viva is over, when I was declared to be not successful. So the cumulative would be A plus B, written examination plus viva. At the time of giving the exam, no cutoff marks for viva. And the rules come in 9th of March 2016, formally introducing this cutoff marks, my lords, at the end of, at page 287, general instructions.
Thereafter, this is all.
Thereafter, so there was a.
So they differed, both of them differed.
They differed.
He finds
Then-
32 here, you know. Yeah. No, both of them differed.
Yes.
And first of all, when you filed a writ petition here, did you get an interim order?
No, we got an interim order. The
See?
next election, which was scheduled for 17.
Keep them
finally
post
it was-
aside.
Yeah, they said that. my
We
lord.
saw that. So there was an interim order which says that direction to keep
No,
them post,
it's a very,
post
it's a
aside.
slightly peculiar interim order, but we got an interim order.
What
It
is the
says-
date of that interim order?
It says 9/5/2017, 4/5. So it says that if the selection process continues, the last selected candidate shall be intimated that his/her selection is subject to the final result of this writ petition. The selection finally happened, I believe, in 2019 and 2021, in 2021. So 17 was this interim order.
2017.
17, and the selections happened in 2021. So it says that the last selected candidate shall be intimated that his/her selection is subject to the final result of this writ petition. So there are 4 selected.
but they've deferred. They deferred on October 16,
Yes.
right?
Yes.
And then the interim order came to be passed in May 17.
Now,
What
just
is the
because
date
of the
the
difference of opinion, may I read that judgment?
7th October 16. Okay, at the end. October.
That's right, you know. इसको निकाल दो। That's fine. Salam, salam. क्या चला? So, well, this the difference of opinion happened on 7th of October 2016. Well, these three issues actually arose for consideration. That's why I said the questions in my case will be slightly. May I hand over these three questions, which according to me arose?
The only difference between yours and the previous one is
Yes.
that after the written test was over in October 2013,
Yes.
filed a writ petition and all that.
Yes.
Full court decision was in 12th of January 2015,
That's right.
which interpreted the rules and said that the rule enables the authority, the court to adopt procedure.
Whatever proceed. Yes.
So you say that that rule won't apply, it's procedural rule, but then they referred to that rule and imposed this 40%.
That's right.
And now that is January 2015 full court.
Yes.
And they informed you on 29th January. We just saw that. 29th January, they informed you
That's right.
within about few days thereafter.
No, they did not inform.
And after
Yes,
that,
sir. No, I'm sorry, man. With respect.
Doesn't
They
matter.
informed me for the Viva Voce. I
about
was
the
not
Viva
informed the full court resolution ever.
about the Viva Voce,
Yes.
that there will be a Viva Voce now.
That's right.
That's all, is it? They didn't
That's
tell
all.
you about this 40%.
Nothing. The full court was, I came to know only through RTA.
Okay, anyway, the Viva Voce was conducted thereafter in
Thereafter.
February 2015,
12 to 2015.
right?
Yes.
Then finally, they
Thomas
passed,
was not.
then the decision was on 16th February 15 when they said that you are not eligible for the reason that
I'm aware.
you got only 18 marks out of 40 marks,
18.8 out of 50.
18.5 out of 40, which you challenged here again directly.
I challenge that.
2015, Mr. Mukherjee, again,
Yes.
same.
It was filed in 2015. It was filed in 2015.
You have to take a call. What does it say for the Viva? That all candidates who have obtained 60% or more marks, the written exam shall be eligible for Viva.
Yes.
And selection of candidates shall be made on the basis of cumulative grade value obtained in the written and Viva Voce.
Viva 50 marks. There was no cutoff. So it is acknowledged that the cutoff was introduced only by the full court decision. That accepted position is till that full court decision, there was no cutoff marks for Viva. A cumulative of that exam where 60, 50 are the two stages for two eligible sets of candidates, plus the Viva. So if there are competing interests, they will obviously take the topmost. Incidentally, I was the only candidate. So whether I should get a margin or not, that's another aspect of the matter. My learned friend will argue no indisputed right that I should get appointed. That's another aspect of the matter. We are only in the procedure today. The procedure as it existed did not broach of any Viva cutoff marks. That's the submission.
So why are you saying that the reference won't apply to you?
The reference, Manos, I'll tell you, Lordship, because the difference of opinion of the two learned judges here was on three major issues.
Was on the interpretation of the
On the
section
interpretation
of the rule.
Of the rules. This is
So if we hold it, if we accept one of the views that this provision
is only procedural and not intended to empower amendment or addition of a cutoff,
That Justice
then in
Shivkirti
which
Singh
case,
said so.
that's the point of distinction.
That's
isn't
the
it?
point of distinction. The point is, and there are actually, may I just show the three questions which we had raised before the division bench? And the two learned judges differed on all three. Justice Bhanumati held all three against us. Justice Shivkirti, all three in our favor.
What are the
He
three?
also goes to say there's malice in law at para 45 of the judgment. Very good, very good.
Ten years, what can we do for your client now?
I was telling you, I was going to answer the question that this was wrong, but I don't know, because today apparently I believe
What's your client doing?
the lawyer is practicing.
Practicing.
How old is he now?
He should be 46. Because 2013 was the person 35 plus.
Now he can aspire to become a High Court judge.
Is it really, I mean,
Easier
very
said than
seriously,
done.
is he really interested? Because
Right, that's why I
joining
said,
now,
no?
I mean,
At 46, we'll have no career ahead in
no
the judiciary.
career at all.
Why for this, with respect to the smaller states, Manoj, the progression is faster than in these larger states.
No, not always. I'll tell you why. The vacancies are fewer also.
This was only one single advertisement, single post advertisement.
Singapore, that
So
point.
therefore vacancies, as the Chief Justice pointed out.
Later on, it happened four came about.
So there are always,
See, my brother is telling that the
The
exam was
advertisement was cancelled and thereafter the vacancy was clubbed with the subsequent advertisement.
Later on, 2019 and 2021.
So therefore.
That is where I
this-
got this interim order in my favor.
So therefore, this exam, this advertisement of 2013 did not culminate. So it got cancelled in between.
No, 2013 never got cancelled.
Ah.
The subsequent examination got cancelled.
Subsequent wala.
It was not 2013. 13 went through his usual course of
Okay.
being
Subsequent
eligible,
got
knocking me out, and then my
Maybe
RTI.
Now, after 10 years,
We kept on trying to get the matter listed. Manoj, that's the only
Yeah.
thing I can lament, Manoj.
The great biggest concern is Mr. Mukherjee, the time that
It was 21. I'm sorry, Manoj.
just like this, when we've understood that we have kept the matter pending here, but then what do we do at this stage?
In fact, one of the difference of opinion with my with how I have understood the two judgments. But Tej Prakash was just touched upon, noticed by Justice Bhanumati, say a reference is pending. Justice Shivkirti Singh says it does not matter. That reference does not affect the facts of these cases. So therefore, those three issues which were raised and answered are I've summarized it here. The suffering continued with the full court resolution, knocking me out at the first stage, not including my name. Then the Supreme Court having a difference of opinion. And I'm
what is to be
May I just-
done according to you here?
just one interjection. Very,
Yes.
very.
Here, Mr. Rana says, Rana Mukherjee says, Mr. Mukherjee says that, look, First, you told him that he is not qualified.
He is not qualified, my lord. I will show to your lordship. My
Then
learned
he
friend
gives
says
an
there is no law.
RTI. After the RTI, you tell him you have qualified.
No, not after.
Then you call a full court and change the resolution.
No, that's what I'm
And
saying.
finally, you tell him
No,
that,
no,
look,
that's
now
what I
you're
wanted
not
to show to
qualified.
your lordship, my lord.
You don't get
In fact, my
40%.
lord, the High Court, my lord, in law, again, appearing for the High Court, my lord, I can justify, my lord. In law, my lord, he is not qualified. The advertisement was for an unreserved post. For unreserved post, minimum qualifying marks to appear in the Viva, my lord, is 60%. He gets 52% in return. Then he made a representation to the High Court.
Where do you get that?
Yes, my lord. Would your lordship see the advertisement? First, my lord. The advertisement is at page 111 of the PDF.
Right.
Okay.
Do you see the list of dates? Page, what is the page of the advertisement?
No, for first thing, my lord, I'm saying the advertisement, lordship would see page 111, which is PDF 111. Number of posts advertised is unreserved 1.
Yeah, we got it.
And now the lordship may kindly see the rules. The entire rules are, my lord, at 397.
You just tell us that page where you want us to go. You just tell us that page where that 60 for that mark.
Yes, my lord, my lord, first 111, my lord, 111.
Okay.
That is the advertisement, my lord, which will show 15th May 2013, one vacancy, particulars at the bottom of the page, unreserved 1 vacant post. This is an unreserved post. Now, my lord, lordship may kindly see the rules now, which is 397, the entire rules, my lord. My learned friend quoted from some part of it. The rule says, my lord, page 397, it starts at 401. For 25% direct, it should be as per Schedule B.
What is there? It says grade 1.
Yes, my lord. Grade 1, that is, my lord, that is 25% direct recruitment. Page 401 top. Grade 1, that is, my lord, direct recruitment. On the last column, lord, should we get direct recruitment. 25% of the post should be conducted as specified in Schedule B of the rules. My lords have got it. Middle, my lord, third column.
Not exceeding 25% of the posts in the CADA.
Yes.
Maybe filled by direct recruitment.
On the basis of aggregate marks secured in the competitive examination conducted by High Court as specified in Schedule 1 of the rules. Schedule B of the rules. Now, Schedule B, lordship would get it, my lord, at 428.
Not able.
That 60%. Lord, for direct recruitment, 428, my lords have got it.
401, right?
Yes, 401 first, my lord. Yes, I'm so sorry.
Just read that, not exceeding, आपको मिला?
401 says, my lord.
Not exceeding 25%.
Yes, it's part of Rule 7 column. Not exceeding 25% post in the cadre may be filled by direct recruitment on the basis of the aggregate marks grades secured in the competitive examination conducted by the High Court as specified in Schedule B of the rules.
Change in your. So this says this is only the quota for the direct recruitment.
No, yes. Then lordship will go to Schedule B.
As per Schedule B.
Yes. Now lordship may kindly see Schedule B at 428.
Mr. Hansaria, take us to 428 directly.
Yes. Schedule B 4. Then look, there are 3 papers. Interview 50 marks. At 430, bottom, all candidates who obtain 60% or more marks or corresponding grade value in the written examination shall be eligible for Viva posts. Provided its schedule types who obtain 50% the corresponding grade will be eligible for Viva posts. Look, this will apply for the reserve category. For the general category, seat.
Below general instructions.
This is general instructions, my lord, of part of Schedule B.
Provided the scheduled caste, scheduled tribe candidates to obtain.
You have to get 60%.
50% marks or more.
For SC/ST, it will be, my lord, 50%. But if it is SC/ST reserve seat, my lord, But since the seat was, my lord, a not reserved
It's a
seat,
general
it was a
category.
general seat,
So the
You have-
cutoff is 60%.
60%.
This person has obtained 52%.
52%, he gave a representation. But it was a new high court in 2013 constituted. For the first time recruitment made. They considered all like there are no available candidates. My lord, in fact, that principle, somebody could have challenged it and saying that his calling of interview is bad. Appearing for the high court, I can't say that decision is wrong.
No, but that, Mr. Hansaria, you may not be correct.
Yes,
A reserved category candidate may also contest for an unreserved seat.
yes, my lord.
Now, see what it says, provided
Yes, my lord.
that scheduled caste, let's see the whole thing.
Yes,
All
my lord.
candidates who obtain 60% or more marks for corresponding grade in the written examination shall be eligible for viva voce.
Please, your lordships.
Provided that scheduled caste, scheduled tribe candidates
Yes.
who obtain 50% or more marks or corresponding grade in the written examination shall be eligible for the viva voce.
My lord.
Now, this does not say only in respect
Reserve-
of a
My
reserved
lord, I
seat.
understand, my lord. What I'm saying, my lord,
If it's a
it is-
scheduled caste candidate.
my lord, it
yes,
is a
It happens
possible.
in every school, college admission, my lord.
No, my lord.
Cutoff is
School, college admission happens like that.
Competing for a general.
Yes, that's not for reserve post. For reserve
it's
post,
for
it's
any
different
post.
criteria.
For any post.
Yeah, for any post.
It is, the concessional mark is applicable to the candidate, not.
Not to the
relative
post.
My lord, it is post, my lord, that is, my lord.
No,
what-
no, it can't.
Very,
It's
my lord,
can't
High
be.
And
High
once
Court having
the-
called him, my lord, I
The
cannot.
High Court says you are eligible to appear
My
for
lord,
the
that's
viva
why he
voce.
made a
How can you
repre-
argue that you are not.
Initially, High
eligible?
Court thought it is not. High Court made a representation. Lordship would kindly see thereafter, my lord. After that, in the same page
That means he was
431.
eligible to appear for the viva voce.
I'm so sorry, my
He
lord.
was eligible to
Very
appear.
well, Lord, that he has been made a pillar. What I'm saying is 431 at the fourth, all necessary steps provided rules under this shall be decided by the recruitment committee. Thereafter, my lord, what is important is this, the mode of evaluation, page 431. After that quotation, rule, all necessary steps not provided in these rules. So, my lord, it is silent, it is does not similarly required. For the recruitment, it shall be decided by, then thereafter, my lord, the mode of evaluating the performance of the grading in the written and viva shall be specified below. So, my lord, both has been given. Grading and, my lord, for both written and viva is below. Now, below is, my lord, the chart is there at page 432. So this chart is applicable for both written and viva. Now, in says percentage of marks, O is outstanding. My lord, this gradation, my lord, is not only in these High Court rules. For example, my lord, I have been checking on the line, National Institute of Technology. It also, it's, my lord, here it does not, so O is outstanding. A plus A, B plus B, C plus C, and F. F is in fail. If it is written, my lord, in others.
Simple case where after the subsequent resolution,
Yes.
you prescribed a cutoff for viva voce. And in that viva voce, he according to you obtained 18 marks.
18.8.
18.8 as against the 40
My
required.
lord.
That's the reason why you.
My lord, what I am saying, my lord, this.
Therefore, all other points that
No,
you
no,
are making.
full
which
court
have
has
no relevance
interpreted
to
these rules, my lord, and made it clarified. I'm saying it is not introduced for the first time, it is a clarification in nature. If a lordship see the full court resolution. Full court resolution quotes these rules, my lord, and also, my lord, the earlier part, and say, my lord, we will go by 40%. And can I not, my lord, an appointing authority?
Where is the requirement of 40% in the rules?
No, my lord, that's what I'm saying, my lord. Below 40%,
Where?
is this chart, page 432, which is, my lord, necessary for evaluation for both written and viva.
Read that, please.
My lord, a 431 bottom, it says mode of evaluation of performance of candidates for both in written and viva shall be as specified below. My lords have got it, my lord. 431.
Okay, but this is say, this is.
Mode of
Okay,
evaluating.
that's why now go ahead.
I'm so sorry, made.
Go ahead. So.
Yes, evaluating performance in the competitive exams for judicial selection, system operates as follows. All question paper carry numerical, etc., etc. Then the tabular will then convert the numerical marks into grades, 7-point grade corresponding as value follows. Then, my lord, these grades are given 70%, etc. You get so, and so. My lord, if you got below 40%, it is F.
That 40% is not confined to viva voce.
My lord, it is written, my lord, it is the same standard. My lord, what the rule says, it is the same standard for written and viva. That is 431. That's why I was reading 431. The mode of evaluating the performance.
It's merely saying, because there was no prescription of having viva voce to be evaluated separately.
That's
Because
right.
there was no cutoff at that point of time. These rules relate to that period. So they say that anybody who obtains
Less than 40.
outstanding 70%, he will
Yes.
get grade 7.
Yes.
And anybody in a totality of the marks gets below 40%, he will be a F candidate and the grade is 0.
And F get,
To say, what has this got to do with your?
no, what I'm saying, my lord, before that, if I'm sorry, I've not made clear. 431 says, this tabulation, my lord, relate the mode of evaluating performance of grading in the written and viva
Yes, it's end by it has
shall
to
be as specified below. So, my lord, this tabulation or mode of evaluation of gradation system,
He's saying, is it your argument saying that you first of all take the written examination and then see whether 40% is prescribed, whether he is falling under this category, then he will be eligible, then also have a look at the Viva VOC also.
yes,
And then the 40% has to be seen even for
for both.
Viva VOC separate.
Also, yes, and that is how, my lord, the full
Then
court
if
understood.
that was the way, that's the way you should read the rule, then your
No, my
whole
lord, that's
full
why,
court was unnecessary.
then, my lord, we changed the rule because this
Then
proceedings.
why did you call for a full court then?
No, that's what let me explain that, my lord. Then, my lord, in full court took that decision, my lord. It is more of a clarificatory nature. In any event, before this, my lord, the interview was held by the full court.
And this scheme which you are showing commencing at Schedule B
Yes,
existed in the rules from the very beginning.
I'm so sorry, my lord. Yes, it's 2005 rules, my lord. The new High Court comes in 2013, Manipur High Court. And 2015, before the interview.
And you know, one more thing,
Yes,
this conversion, the rules prescribe, see, it's for each question.
my lord.
It's not for the overall exam. See how it is. Let's go back to internal page
Numerical
39, that is 431.
The-
The mode of evaluating the performance of grading in the written and viva voce examination shall be as specified below.
Yes, my lord.
Now, the system operates as follows.
Yes,
The questions in the question paper may carry numerical marks for each question.
my lord.
Okay. Now, the examiner may assign numerical marks for each sub-question which may be totaled up and shown against each full question in numbers. Now, the tabulator will then convert the numerical marks into grades in a 7-point scale with corresponding grade values as follows, which you showed us.
Please, your lordship.
After converting the numerical marks of each question
Just
into
a-
the appropriate grade,
My lord.
according to the formula given in first column above, the tabulator will reconvert the grades obtained for each question to the grade value according to the value given in the third column above.
My lord.
What is now obtained in the relevant grade value for each answer in the question paper obtained by the candidate in a 7-point scale. The tabulator's next task is to add up those grade values and divide the sum total by number of questions in the answer book, including the question unanswered by the candidate.
My lord.
Applying it to Viva VOC is a far cry, Mr.
Not on this analogy at least.
And it looks about, it refers to the answer book.
It goes on till clause 10. Then the viva comes in, cumulative score. I don't know what Leonard is trying to argue.
The similar vigorous and objective grade value exercise for the Viva VOC
The next
examination
stage,
as well.
yes. After the evaluation is done, after the question papers are evaluated and grades, because I would not get a look in if I had not got 52%. So these grades enable a candidate to get in a step in for the next stage. That's the viva. So 60, 50. I get the threshold of 50 plus. I get a call in for the viva. The viva comes in at the clause 9.
My lord,
The final selection list will be ready by combining
two submissions, my lord.
and the viva will say clause 9.
First is, my lord, the high,
Say schedule to the rule, I say. Competitive examination, schedule B, it's a part of the rule. And then look at the way it is composed. It is putting questions and it is answering questions.
Yes.
See, look at this. Para 6. What happens if there are several successful candidates obtained the
Lord,
same
in
grade?
fact, Lord, these were Assam rules, my lord. These were lifted bodily from the Manipur. It is made for all the states, my lord.
Of course, the situation.
I've checked up. The Assam rules are all identical, my lord.
And 9 is cumulative value of both. Does not,
My lord, what I'm saying is, my lord, apart from this, my lord, before he is, my lord, interviewed, the full court, which is the 3 honorable judges, my lord, who were there, who found that he was not, then he was called. Before this selection, the
Well, follow.
is that all this happened in 2013.
15.
15.
15.
13 advertisement, my lord.
16.
Right.
Let us take it.
Now
to
we are
16.
10 years down the line, or at the least 8 years down the line.
No, I am told.
We'll
I'm
leave
told
it at that,
we-
Mr. Mukherjee.
No, may I say this first? I believe,
We can't spend more time in a
No, I understand.
constitutional bench in a matter like this.
no, I'll tell you,
Let's
Lordship,
close it by saying that, the selection relates to the year 2013. Selection process took place in 2015. At this stage, it is not possible to get you
so
appointed
the
as a.
question of the full, this reference would remain, my reference, no, I'm not talking of Tej Prakash. The reference in this, the
It's
division
not
of
necessary
opinion.
to answer the reference in this case.
Reference will answer in that matter.
No, that, my submission is Tej Prakash is not attracted to my case. That's what I said at the beginning. Because of the difference of opinion, the issue will still be at large. Because if I follow Naushad, my lords,
On the facts, we don't have to answer this now.
Like at the very beginning, you have distanced yourself from the Tej Prakash.
yes, because
Distance, you said that I'll make submissions at the.
that's right. So that's what I was trying to submit that.
But on this.
My issues are different here.
Because of, for resolution of.
I believe 2 posts are filled up by retired judges. May I take the interim order to my advantage? I'll just pick two submissions. Just one minute, sir. Two
It
submissions.
is not a case, my lord, where anybody who is got lesser marks than him has been appointed. And at page 431, my lord, I'm so sorry.
Mr. Mukherjee, also there's the issue of the reference doesn't arise in this case.
The Tej Prakash issue does not, the reference in my case arises. The difference of opinion.
That is
Ah,
because
the
of
but
difference
that
of
has to go
opinion.
before 3.
Yeah, that should go. Now just two submissions, because on this, what your lordship said, I believe because of this interim order, the last 2 posts are filled up by retired judges and they are appointed 2 years in rotation. I would still have 14 years of service, my lords. He's willing to, my instructions are he's willing to join. Manipur, lordship sees 2 exams are cancelled, you don't get candidates. Here's a candidate who qualified. Why should he be knocked out like this? The High Court has been obstructing, even here, he's obstructing me, even from arguing.
Oh.
So I don't know why should the High Court start.
I'll sit down because I will stand up when my
Because
judgment
it's not how the 14 are stone wall.
Mukherjee, what we were wondering is that, really speaking, there's a difference of opinion between 2 judges
On rule.
on the application of the rule,
On that, yes, the interpretation.
right? Now, in that case, it has to be resolved by a bench of 3.
Yes.
If the issue which has been referred to the Constitution bench does not squarely arise over here, why should we entertain it? We'll send it back to a bench of 3 judges.
And also equities can be looked into by that bench and then say
Then
because one.
could I make a soft request, my lords?
Yes.
Subject to your lordship's convenience. Could this be listed as fast as
Yes,
possible,
yes.
my lords? Because
We can.
every day I'm
We
losing
can,
time.
we can.
Every day I'm losing time.
Just The proceedings have been on, on 7 October 2016. The bench of two learned judges, which was considering writ petition civil 294 of 2015, deferred. Full stop. Now, when was it tagged?
Then it just said August 2017, my lord.
Right, I got it. Thereafter, on 10 August 2017, a three-judge bench passed the following order. वो copy कर लीजिए. So, from the above narration, it emerges that the direction to tag the matter with the reference to the Constitution bench in Tej Prakash Pathak versus Rajasthan High Court 2013 for SEC 540 was on the submission of learned counsel appearing on behalf of the contesting parties that a similar question of law had been referred. But stop. During the course of the hearing, Mr. Rana Mukherjee, learned senior counsel appearing on behalf of the petitioners, submits that
these questions arise for. But that we had variance with the Tej Prakash reference, so it will be easier for me to argue there. But we can have, I'm sorry. Fine. I'll give you a copy. I will not have it here.
No, there are other questions.
Mr. Rana Mukherjee, learned senior counsel,
No, there are other questions.
appearing on behalf of the petitioner, submits that submits that the following three questions would be sought to be urged in the course of the decision of the reference to the three judges, to the three-judge bench, colon, ये 1, 2, and 3 copy कर लीजिए. Just a procedural. Yes. Procedural fairness and fairness.
No, there are other questions also arise. Otherwise, Lord, I will be foreclosed from arguing.
Mr. Vijay Hansaria, learned senior counsel appearing on behalf of the respondent, states that he would wish to raise certain other questions.
Lord, which I have raised, Lord, in my submission.
We are keeping it open.
Since in view of the statement which has been, since in view of the above position, it emerges during the course of the hearing that a reference to the Constitution bench along the lines as in Tej Prakash Pathak is unnecessary. But stop. The difference of opinion between the two-judge bench between the two judges would have to be resolved by a three-judge bench. But stop. We accordingly direct the registry to add the present case to the list of three-judge bench matters and to seek an assignment to an appropriate bench at slightly higher at an early date.
If there's earlier order of
at an early date, I'll take it. I have to assign that. I'll take the registrar.
I understand, madam. The pressures are.
No, I'll immediately do that.
I'm deeply obliged, madam.
Yes. Yeah, we'll have to decide that Tej Prakash in that matter.
I'm deeply
Easier with